morning, everybody. Welcome to the Melbourne Law School. I'd like to begin by acknowledging the Wurundjeri people on whose lands we meet tonight and where we teach, research and learn here at the Melbourne Law School. And I pay my respects to First Nations people, First Nations elders, past and present, and any First Nations people in the room with us tonight. My name is Professor Heather Douglas and I'm the Associate Dean of the Melbourne Law School, and it's my pleasure to welcome you all to the 2025 Annual Tax Lecture hosted by the Melbourne Centre for Commercial Law. The Centre brings together research, teaching and industry engagement across all areas of commercial law and policy, with broad reach into both policy, industry and academia, domestically and internationally. It also operates a master's program that is internationally recognised, and its students are some of the best placed globally to forge their own impact across commercial law, partly thanks to the experts that the Centre welcomes to teach into that program, and also obviously the teachers that we have at Melbourne Law School. Within the Centre, the Taxation Law and Policy program, which supports tonight's event, has established itself as a world leader in research and advocacy on tax reform and tax justice. This annual tax lecture is a centrepiece of the program's public engagement. Tonight's lecture will examine significant developments in global tax governance, the proposed UN Framework Convention on International Tax Cooperation, which aims to transform how international tax rules are made and who they serve. Central to this is the growing call from developing and transitional economies to shift global tax policy making from the OECD to the United Nations in pursuit of a more inclusive and equitable system. Tax justice has long been a hallmark of the Taxation Law and Policy program, a focus led by Associate Professor Catherine James, who I'll shortly invite to introduce our guest speaker. Catherine teaches and researches in taxation law and policy here at MLS, with a particular focus on the relationship between tax and distributive justice. She was recently a very prestigious IARC Discovery Early Career Research Fellow. I'm looking forward to her future fellowship in the future, examining reform of Australia's GST. She's the founder and convener of the Community Tax Project, which goes from strength to strength every year here. It's an alliance between academia and the community sector advocating for tax reform to advance social equity. After the lecture, there'll be a Q&A, so opportunities for you to ask questions, and there'll be a roving microphone, and Catherine will moderate that Q&A. So I'll now invite Associate Professor Catherine James to introduce the guest speaker for this evening. Thanks.
Thanks so much, Heather, and welcome everyone tonight, and just acknowledging the acknowledgement of country. Thank you, Heather, for delivering that so well. It's my pleasure to welcome you here tonight for our annual tax lecture, and we've got an international focus here with a kind of loci of setting the rules for international taxation appears to be possibly getting challenged and changed from the kind of traditional OECD focus to the UN. And so we've got our distinguished speaker, Annet, to speak to that tonight. Annet is a Professor of Taxation and the Director of the African Tax Institute at the University of Pretoria. She's the author of the groundbreaking book, Base Erosion and Profit Shifting, a blueprint for Africa's response, and she's an expert in international tax, and so is well placed to guide us through the lecture tonight. She has many prestigious fellowships and has many high-level advisory roles, including as a board president of the South African Institute of Tax Professionals and as a commissioner of the South African Law Reform Commission. Annet is teaching into our master's program this week and is teaching international tax into our master's program. She's one of the many international experts that we're really very fortunate to welcome here to teach into our program, as well as our practitioners and academics who teach into the program too, some of whom are here tonight, and so welcome to you too. So without further ado, Annet will speak for about 50 minutes and then we'll have questions on the topic. So really looking forward to learning more and hearing her ideas tonight. Thank you. Join me in welcoming.
Thank you so much. It's a pleasure to be here. Thank you for the welcome. I thought it is summer here, and then I came here pretty cold. It's a lovely country. You have beautiful campus that you have here. It's really a pleasure to be here. I've enjoyed the class, and I hope we shall enjoy the lecture. So we have some developments that are shifting the international landscape and governance at that I'm going to deal with. The title is the UN Framework Convention on International Tax, and we are going to look at the pitfalls as well as the gains that we could get out of that. And I thought that we are going to have a mixed crowd here, and rather than getting deep down into the international tax issues that are involved, I thought we would really understand the story. How did it start? What is actually happening? Because I can assure you discussions are taking place as we speak now. So let's take it easy so that we get everybody on board, and I will get started. So that is our beautiful University of Pretoria. You're all welcome to South Africa. So I'll start with a few introductory remarks. As some of you may know, there is currently no global tax organization, all right, that is legally constituted to set international tax norms. Instead, international organizations such as the OECD and the UN have taken on various initiatives in international tax norm setting. With the increasing concerns from developing countries about the legitimacy and inclusivity of these organizations, the tide changed in 2022 when the UN passed a resolution on the promotion of inclusive and effective international tax cooperation to be effected through a UN Framework Convention on International Tax Cooperation, which I will refer to from henceforth as the UN Framework Convention. A member state-led, open-ended, ad hoc intergovernmental committee was established in 2023, which drafted the terms of reference for the UN Framework Convention. Essentially, this sets the stage for the formation of a global intergovernmental tax organization under the auspices of the UN. The UN Framework Convention is viewed as a momentous achievement by many developing countries which have questioned the legitimacy and inclusivity of the norm-setting initiatives of the international bodies like the UN and OECD. However, there is also opposition against the UN Framework Convention among some UN countries, and these are largely developed countries, and their objection may actually derail the objectives of the UN Framework Convention if those objections are not addressed. Now that the development of a system of governance for international tax cooperation has been approved by the UN, this presentation highlights the potential gains that this UN Framework Convention could offer in achieving sustainable international tax cooperation. And then I'll also set out the potential pitfalls and maybe come up with recommendations that we hope could address some of these challenges. So before getting into the nitty-gritties of the UN Framework Convention, let us set up some background and also discuss some of the initiatives of these international organizations that they've been involved in setting the norms, explaining their entrenched allegiances and the positions that they have taken over the past, which have been the reason why we are at the place where we are now. So initially, the international tax system consisted mainly of countries' domestic tax laws for taxing foreign source income of their residents, and also the domestic source income of non-residents. As there was limited cross-border trade, international tax challenges like double taxation were not a serious problem. This situation changed after the two world wars and the increased need for taxes to rebuild countries' economies, especially those in the global north. The first efforts at coordinating the international tax system were made by the League of Nations, which was formed after World War I, which adopted a model tax convention to eliminate double taxation, but most developing countries had no role in the formative stages of this model tax convention, which has got the policies that underpin the current double tax treaties that we have today. After World War II, the League of Nations work on the Model Tax Convention was taken over by the Organization for European Economic Cooperation, which was succeeded by the OECD in 1961 when Canada and United States joined that organization. In 1963, the OECD produced a draft Model Tax Convention on income and on capital, which was finalized in 1977 and has been revised over the years, with the most recent one being the one for 2017. The OECD model is largely in favor of developed capital exporting countries in the global north. So what has the OECD been up to in forming in international tax norm setting? Until the 1980s, the OECD work centered around its model tax convention, which dominated and disproportionately allocated taxing rights from cross-border transactions to capital exporting countries. But from the late 1980s, the OECD started extending its influence beyond issues of tax treaties and actually beyond looking into issues for its own member states. For example, in 1998, the OECD and the Council of Europe released a multilateral convention on mutual administrative assistance in tax matters. But with increase in issue of tax transparency and increase in the need of automatic exchange of information and the global focus on those issues, that multilateral instrument was updated by protocol and actually open for all countries globally to use for exchange of information in tax matters. And then in 1998, the OECD issued a report on harmful tax competition. This was an onslaught in tax havens and preferential tax regimes, calling them to reform their ways, otherwise they would be blacklisted. At the time, the OECD focused on only tax havens, and it got a bit of backlash for the heavy-handedness that it approached towards them. In 2002, the OECD Global Forum on Transparency and Exchange of Information was formed, involving non-OECD countries that cooperated with the OECD, and there were peer review processes that went on to ensure that countries comply with those standards on exchange of information that were developed. In 2012, the OECD launched its BEPS 1.0 project, which culminated in 15 action measures in 2015. The criticism was that developing countries were not involved in the setting of the agenda of the BEPS action measures. So in 2016, developing countries called on the OECD to come up with a more inclusive framework so that they can participate in it ostensibly on an equal footing, to make sure that all countries come together to implement the BEPS minimum standards through a peer review mechanism. Currently, the OECD is driving the BEPS 2.0, where we have your Pillar 1 and Pillar 2 that are the buzzword in international tax of recent, to deal with new approaches of taxing the digital economy. Although developing countries have been involved in BEPS 2.0, they have not actually participated in an equal footing with developed countries, as they have not had much influence in setting the agenda for the work. Now let's look at the UN. What has it been up to? The UN Economic Social Council has historically been responsible for the UN's work, and it didn't do a good job with that. Its first initiatives were in the 1970s when it established an ad hoc group of experts on international standards of accounting and reporting within the UN Center of Transnational Corporations, which recommended binding disclosure rules for multinationals and actually came up with a code of conduct for multinational corporations. But the OECD and the business group lobbied against these things and blocked the adoption of these recommendations, such that in 1993, the UN transnational corporation was actually abolished, only to pick up country by country reporting in the OECD BEPS Action 13 later on. In 1968, the UN formed an ad hoc group of experts on tax treaties between developed and developing countries to address the concerns of source-based countries about the unfair allocation of taxing rights. In 1980, the UN came up with its own model tax convention, which was revised over the years. The current one is the one for 2021. With the exception, though, of a few articles that favor source countries, much of the UN model is largely based on the OECD model. Now, as the mandate of the UN ad hoc group of experts extended to other international tax cooperation matters besides tax treaties, in 1980, it was renamed the Ad Hoc Group of Experts on International Cooperation in Tax Matters. In 2025, its status was upgraded to a Committee of Experts on International Cooperation of Tax Matters, comprising of 25 members, the majority of whom are from developing countries, but they serve in their personal capacities rather than as government representatives, a distinct difference from how stuff is done at the OECD. However, the UN's role in international norm setting pales in comparison with the OECD, primarily because of the lack of authority when you have private people doing the work, and also the lack of resources at the UN. The UN committee did, however, support the OECD in the BEPS work, pushing the agenda of developing countries. Of recent, the UN has reinvented itself. In 2017, it has come up with new articles like Article 12A on fees for technical services. And in 2019, it came up with Article 12B on automated digital services, which to address the tax challenges of the digital economy. This approach, which is treaty-based, is differing from the OECD's two-pillar approach. So we have a parallel system that is actually happening right now. However, there is limited indication that developing countries are willing to adopt or renegotiate their treaties to include these new UN articles. The UN is actually working on a lot more other articles. We've been waiting for an updated version of 2025 with a myriad of so many amendments to the article, including Article 12AA on service fees. Services is such a big issue these days, and bringing it up into one article. And they are actually coming up also with a UN fast-track instrument, much like the UN or the OECD multilateral instrument that brought together the BEPS treaty-related measures. So the UN fast-track instrument is another development that is coming up. So this is what these two organizations have been up to over the years. So, despite the efforts and initiatives by the OECD and the UN in international norm setting, over the years there have been increasing concerns from developing countries about the legitimacy and inclusivity of these organizations. For many years, developing countries have been calling for an international tax organization under the auspices of the UN. Unlike trade, where you have the World Trade Organization governing trade, we don't have such a thing when it comes to tax. So there's been issues about tax governance in the international tax world. So if we look at the history of these calls, back in 2021, the UN High-Level Panel on Financing for Development recommended the setting up of an international tax organization. 2012, G77 and China suggested a global tax body should be established under the auspices of the UN as a neutral forum that can dynamically deal with international tax issues. Again, the G77 and China reiterated that in 2015 at the Addis Ababa UN Conference on Financing for Development, but this suggestion was vehemently rejected by developed countries. In 2019, a call to develop a UN tax convention was put forward by Senegal, an African country, on behalf of the African group of countries at the United Nations. In 2021, the UN High-Level Panel report on international financial accountability, transparency and integrity for achieving the 2030 agenda, which is called the UN FACIT panel report, and I had the pleasure to serve on that panel, recommended that an inclusive intergovernmental body on tax matters should be set up at the UN. 2021, the UN General Secretary issued a report entitled Our Common Agenda, which set out a roadmap for inclusive and effective multilateralism, which would lead to a universal and legitimate global tax system. And then at the 44th session of the UN Economic Commission for Africa in 2022, the African Ministers of Finance called the UN to begin negotiations under its auspices to deal with issues of international tax governance, to address BEPS and issues related to tax-driven illicit financial flows. Following this call, on 26 November 2022, the African Union, composed of 54 African states, proposed a draft resolution to the UN General Assembly calling for more inclusive, effective international tax cooperation and a globally inclusive system. So what are the justifications? You can see the crescendo, it's been going on for years. What is the justification for this? Why should we change what has been going on? And I've been alluding to the issue of universality and legality. Since the OECD's frameworks like the Global Forum and the Inclusive Framework are not legally constituted, their legitimacy and lack of universality have been questioned for years. As for the UN, although it has statutory legal basis, it is not an intergovernmental body. Members serve in their personal capacities with limited authority. Then we have an issue about accountability. Although the OECD frameworks comprise of delegates from various governments, their engagements are mainly technical with little political accountability to their governments. There have been concerns about the lack of formal rules of procedure. It is often unclear how the subcommittees of the OECD frameworks are constituted, how they function, how people from non-OECD countries get employed at the OECD. The OECD Secretariat has historically employed permanent staff members only from OECD member states. Then there is an issue of lack of fair decision-making processes. Although the OECD has granted observer status to a number of developing countries, countries have still been concerned and called for a transparent decision-making process, as the OECD's consensus-based approach does not permit developing countries to significantly influence the core and final decisions of the OECD. It keeps jumping. Then there is issues of inclusivity. Although the OECD inclusive framework involves many developing countries, at present it's, I think, over 145 countries are part of the OECD inclusive framework. And although it claims participation on an equal footing, its agenda is largely dominated by commitments to protect the interests of its member states, so it cannot genuinely offer inclusivity. Then we have the problem of duplication of effort. The current international tax efforts forums under the UN and the OECD have overlapping mandates, which have led to duplication of effort, competing standards, resulting in regulatory arbitrage, which undermines the integrity of the international tax system. There has been a need for mutual accountability frameworks. The OECD Global Forum and the Inclusive Framework, they use peer review mechanisms to ensure mutual accountability in the implementation of international tax norms. However, the peer reviews have largely not been effective for developing countries because, this is one of the main reasons, the standards are set without little considerations of the economic and capacity constraints of developing countries to meet the standards that are set. There is lack of clear measures to ensure compliance by states because there is no tax court. There are no tax sanctions if we have a rogue state that decides not to comply. There is also no effective dispute resolution or dispute prevention mechanism when we have conflicts or non-compliance among states. The OECD in the past maintained a list of uncooperative tax jurisdictions that engaged in harmful tax practices, but currently there is no country on this list, but we still know that there are countries there that are doing some not healthy things. Since 2017, the EU issued a list of countries for non-compliance with its own standards and also the standards of the OECD. But the EU's blacklists have been criticized for being impartial. So that is the justification for why we are where we are. And so, despite objections from developed countries, on 30 December 2022, the UN General Assembly passed a resolution at its 77th session on the promotion of inclusive and effective international tax cooperation at the UN. The resolution called on all countries that are members of the UN to work together to eliminate tax evasion, aggressive tax avoidance, and BEPS. Combat illicit financial flows and ensure asset recovery, promote financial transparency, country-by-country reporting by multinationals, and access to beneficial ownership information, and also to ensure automatic exchange of information. And while at it, strengthen the capacities of developing countries to address these challenges. Clearly, if you're in the tax field, this is a marriage of issues that are being brought together in a melting pot. The UN resolution covers various interrelated tax concerns. This approach, though, recognizes the recommendations of the UN FATF panel, which was issued in 2021, which bemoaned the fact that although the ecosystem of the various tax concerns is actually interconnected, the current frameworks do not effectively take this into consideration. The panel called for a holistic and coordinated approach to international taxation, international cooperation, instead of the current siloed approach of addressing these interrelated challenges, and yet they all have a corrosive effect on public trust, financial integrity, the rule of law, and sustainable development across the globe. Support for the UN resolution was heralded by many developing countries as marking a historic step forward towards strengthening international tax cooperation at the UN and paving a way for a UN intergovernmental tax body which would open pathways to reform international tax governance. Although many developed countries were not in favor of the resolution, it was supported and we can see the changes that are going on. So while at it now, let us try to understand what is it they are trying to explain to us about inclusive and effective international tax cooperation. Following the UN resolution on the promotion of inclusive and effective tax cooperation, in 2023, the UN General Secretary issued a report which assessed the current international legal instruments of the UN and the OECD, and actually noted their failure to ensure inclusive and effective international tax cooperation. The report explained the substantive and procedural criteria that should interpin inclusive and effective international cooperation. It noted that inclusive international cooperation requires that all countries should have an opportunity to participate by right without preconditions in agenda setting, in debates and decision making, either directly or in regional groupings. Agenda setting is crucial because it determines how collective action is identified and framed, which often predetermines the scope and the nature of the responses to the relevant challenges, as well as the order of prioritizing how to deal with them. Substantive inclusivity in agenda setting requires acknowledging that countries have different economic circumstances, tax systems, and tax challenges. Therefore, they should all have a real opportunity to contribute to the agenda topics and the options to be considered, and even the calls of action. Procedural inclusivity in agenda setting must consider the different needs and capacities of all countries to meaningfully contribute to norm-setting processes without undue restrictions, and that measures should put in place to support those that cannot do so. Effective international tax cooperation requires that legally established and transparent decision-making structures are set up. The rules should be clear and not adapted to suit the interests of countries on one side of the debate against the other. This effectively implies that all participants should be on an equal footing procedurally and have the same ability to engage meaningfully in decision making. The procedures for engagement should provide sufficient time for all countries to consider their positions and engage in consultations within their governments and with other stakeholders without being pressed to come up with a decision. It also requires that decisions are actually implemented by countries that have agreed to be bound by them when they ratify an instrument. Monitoring implementation of the rules, for example, by use of the peer reviews, must be based on clear standards that are developed by all countries, and that those standards should apply equally to all, taking into consideration the differing capacities of countries to meet those standards. Disputes between governments and between taxpayers and governments must be effectively resolved through an inclusive process that ensures confidence in the system. So that is what inclusive and effective international cooperation is all about. And then the UN General Assembly Secretary came up with options. So how do we get to where we are going? They said, let us maybe come up with a multilateral convention on tax. The viability of this option is, however, hampered by the fact that the UN resolution is covering so many interrelated tax matters for which countries may not easily reach consensus on a common course of action if it's all put in one single convention. So that was dumped. Then the other option was a framework convention on international tax cooperation. We have similar framework conventions like the one on climate change, where we had the Kyoto Protocol that is part of it. Okay, this can be crafted in a flexible manner to cater for the specific objectives of the parties concerned. Protocols could provide for commitments on particular matters depending on the priorities and capacities of the countries concerned. In other words, you can have an umbrella UN framework convention, and then you have protocols on different aspects that countries opt in and out as they see fit. Then the other option was just a framework for international cooperation. That is the current status quo. This is a multilateral voluntary agenda of cooperation where you have soft law systems and recommendations of the OECD, for example. And obviously countries were not keen on continuing with this status quo. At the 78th session of the UN General Assembly in November 2023, it was decided that the UN resolution would be effected through a UN Framework Convention, which is option number 3, which would establish an overall system of international tax governance accompanied by protocol, like I said. So let us see how far have we been from here. I'll briefly touch on where we have been, what has been going on. So a UN member state open-ended ad hoc intergovernmental committee was established as a subsidiary body of the General Assembly with the mandate to draft the terms of reference of the UN Framework Convention, to also set up a bureau, hold sessions, and engage with international bodies on this matter. Their first organizational session was held in New York in 2024, where Egypt was appointed as the chair, and a 20-member bureau was appointed with members from 5 regions, as you can see on the slides. 2 substantive sessions were held in 2024 where the terms of reference were scoped, a 0 draft was adopted, and in December 2024, the final terms of reference were adopted by the UN General Assembly, and a decision was taken to establish an open-ended intergovernmental negotiating committee to actually begin the process of drafting the UN Framework Convention and 2 early protocols simultaneously. So what are the terms of reference? These are critical. First of all, let us look at the objectives. What would be the objectives of this UN Framework Convention? I'm going to run this quickly so that we get to the meat of the issues that were the topic at hand. First of all, that there would be a fundamental principle to ensure full inclusiveness and effectiveness of international tax cooperation in terms of substance and process, establishing a system of governance for international tax cooperation that is capable of responding to existing future tax challenges as well as other tax-related challenges on an ongoing basis while respecting the tax sovereignty of each member state. Then also there was an objective to ensure inclusive, fair, transparent, efficient, equitable, and effective international tax system for sustainable development. They also came up with a few principles to drive what they are all about. And this would underpin a clear principle to follow a universal approach, to consider the different needs and priorities and capacities of countries, especially developing countries, respect for the sovereign rights of countries to decide their tax policies and practices, and while respecting the sovereign rights of other countries. The importance of aligning the pursuit of international tax cooperation with obligations under international human rights law. A holistic, sustainable development perspective that takes into consideration the economic, social, and even environmental policies. This thing is becoming quite massive. Ensuring fairness in allocation of taxing rights is quite important. Coming up with rules which are simple, administrable, and also that are certain for taxpayers and governments, which are the issues we are dealing with right now. Pillar 1, Pillar 2 is quite very complex with a gazillion of pages that makes it quite questionable whether the rules are administrable, and also ensuring transparency and accountability for taxpayers. And then they came up with commitments as UN countries. What are they committed to? Committed to fair allocation of taxing rights, including equitable taxation of multinational enterprises. They are committed to addressing tax evasion and avoidance, including by high net worth individuals, and ensuring they effectively pay tax. They are committed to ensure international tax approaches contribute to achieving sustainable development economically, socially, and even environmental issues. They are committed to ensuring there is mutual administrative assistance in tax matters and issues regarding exchange of information. They are committed to addressing illicit financial flows, tax evasion, avoidance, and even harmful tax practices, and the prevention and resolution of tax disputes. Is literally everything you can think about in the international world. There is big focus on the importance of capacitating low-developed countries to ensure that the needs are taken care of. I've talked about this quite a bit. I won't belabor that point. And while at it, we need to come up with structures that will enable low-capacity countries to actually benefit from that. And there are all sorts of other definition-related issues. Come up with a conference of parties, have a secretariat, dispute resolution mechanism, and the list goes on as you see right there. And then an important one for us to look at is that there was a commitment to make sure that there are actually protocols under the main umbrella of the UN Framework Convention. And here, each party to the Framework Convention would have the option whether or not to become a party to a given protocol. We have quite a number of things involved in there, and they can do it either at the time the Framework Convention is being signed or even later on. They said that at least 2 protocols should be signed. At that time, one of them should be worked on. At that time, the one that was agreed upon was the taxation of income derived from the provision of cross-border services in an increasingly digitized and global economy. Then they said the other one, which I will mention later, would be agreed on later. Then there are the other topics that are of priorities that are also going to be the focus of protocols. So you see them there: taxation of the digital economy, illicit financial flow issues, issues of prevention and a resolution of tax disputes. If you look at double tax treaties, they are only dealing with resolution of disputes, but not prevention of them. Tax evasion and avoidance. So these are the priority ones. But beyond that, environmental challenges and the tax implications, exchange of information, mutual administration, and issues relating to harmful tax practices. Okay, so then how do we proceed from there? A member state intergovernmental negotiating committee was to be appointed to elaborate or to begin developing the Framework Convention. And then also 2 protocols to be developed, submitted to the UN General Assembly in the first quarter of the 82nd session in 2027. So the time is clicking. The first organization session was held in February 2020 this year in New York, where a bureau was elected, comprising of a chair and 17 vice chairs and a rapporteur. The US walked out of those negotiations and indicated that it would not participate in the process, reasoning that the goals of a future UN Framework Convention are inconsistent with its priorities and it represents unwelcome overreach, which would unacceptably hamper its ability to enact its own tax policy and to serve the interests of its citizens, its business, and its workers. The US called on all other countries to walk out of these discussions, but none of them did. And after deliberations of other aspects of the agenda, a crucial one arises. How do we go about decision making? It was agreed that the UN negotiating committee would first exhaust every effort towards reaching consensus, taking into consideration the time frame. They have to be done by 2027, which usually falls around September, October it is. If consensus is not reached, then voting on issues of substance shall be decided by 2/3 majority in terms of Rule 161 of the UN Rules of Procedure of the General Assembly. With respect to the second priority topic, remember they picked the one on services and the digital economy, they picked on dispute prevention and resolution, although many developing countries wanted the one on illicit financial flows. This one was picked by consensus because they thought that it is less controversial, I wonder so, and that it would receive broad support, and it could be possible for them to actually work on this protocol and have it ready within the time limits that are provided. So that is why this one is the second protocol that was agreed on. And then they said all the other list that was there will be dealt with as future protocols. What are the working methods they decided? They said there will be 3 work streams. One of them will deal with drafting the main umbrella framework convention, and then there will be one to deal with the one protocol and the other one to deal with each protocol. Each work stream would be led by 2 vice chairs, one from a developing and one for a developed country. And the roadmap was that they would have 3 substantive sessions every year in 2025, 2026, and 2027, which would lead to the finally coming up with the final text of this framework convention, which is supposed to be submitted together with the 2 protocols at the 82nd session of the UN General Assembly in 2027. As we speak right now, the last session of 2025 is actually taking place in Nairobi. These sessions are taking place in New York and Nairobi. So there it is. They have actually started drafting the meat of the convention. There is a glimpse of the draft as they meet. There is Article 4 developing on fair allocation of taxing rights. I will let you look at what is happening. They are yet to develop the details. 11 to 21 is not yet inserted. 22, how is this big convention actually going to interact with the rest of the other protocols they are going to work on? So this is happening like now in Nairobi, Kenya. Okay. So we are all on the same page, I presume, and the questions are arising. What are the pitfalls of the UN Framework Convention? Number 1, buy-in from developed countries. Since the international tax policy norm setting has long been dominated by the OECD, obviously it will not be willing to cede this role to the UN. Many developed countries argue that the OECD has made substantive strides to reform the international tax regime, and the momentum that has been built may be lost if its work is moved to the UN. And it's also going to shift focus of the international community to the UN Framework Convention. Remember, now we are in the inclusive framework. There is these 2 parallel things. People have got so much of international people that can be involved in this session and in this other program that is going on. So we have an issue of diverting scarce resources. We have an issue of undermining and distracting the ongoing work at the OECD under the Pillar 1 and Pillar 2 solutions for taxing the digital economy. So those are some of the issues regarding the pitfalls. Funding is a big problem. efforts by the UN to champion the cause of developing countries have for years been hampered by direct or indirect denial of funding from developed countries, which have historically preferred that international tax norm setting is actually handled by the OECD, ostensibly because maybe it's more efficient in handling these things. Technical capacity goes hand in hand. It is trite, like unlike the UN, the OECD has more resources and technical capacity to work on the various international tax issues, in part due to the steady funding from its member countries. Then let's look at the negotiating capacity of developing countries. The negotiation of any treaty, any convention, requires preparation, a clear tax policy, understanding the economic implications of the relevant instrument you're discussing, understanding the matters you're negotiating and those you're going to take a firm stand on. Reaching those negotiating goals requires a united front, especially when you're going to do it together, which may not be that difficult for so many developed countries because they generally have the same level of economic development, generally in the same geographical location, in the EU, for example, and they can easily get together with less cost and caucus on the different issues they want to galvanize themselves on. This is not necessarily so for developing countries that are spread all over in the global south. Many of them are bedeviled with geopolitical and socio-economic concerns that their politicians are putting priorities in. Many do not have the effective, they don't have the capacity to engage in these global discourses, and they don't have a lot of experience in the myriad of international tax issues that we have just pointed out. And another issue for many developing countries is that there has been this inherent distrust among one another, which was perpetuated, obviously, by the historical divide and rule tactics, colonial tactics. They also force monetary and staffing constraints that we are talking about, and many of them don't have the capacity to spread the few people they have to go to all these different forums that are dealing with the international tax issues. Then here is another one. There is an issue of soft law. Some argue that the UN Framework Convention may not elicit responsiveness from countries as they are generally skeptical to be committed to legal binding instruments. So over the years, countries have shown more responsiveness to soft law commitments when they are unable to willingly forge formal legal frameworks to address a particular collective action problem. Rather than remain unresponsive to international problems, states have used soft law commitments whose compliance-inducing nature is not strictly binding on them, but is nevertheless powerful enough to drive their motivation. States are more responsive to soft law as this enables them not to delegitimize international law by ignoring it. Essentially, adherence to soft law is garnered by a subtle carrot and stick approach. The carrot is the supposedly good cooperation repetition that a country gains for being a member of such a framework, which is quite strong enough to attract countries to be involved. And the stick is the subtle pressure and risk of sanctions and blacklisting and trade tariffs if they are not caught up, if they don't get involved. So you see that even at the UN, we have so many conventions that have come up, but are they being adhered to? So that is something. Should we follow something that is legal or follow soft law? It has been working under the OECD. The UN Framework Convention is also hampered by its own design of having an umbrella and protocols, because if there is no traction or people find no interest in certain protocols, it's just going to delay the process, and yet they may be actually the protocols of interest. Some have argued that the dynamics of developing countries may not actually change also at the UN, because those those that have not been able to participate in the current forum because of whatever constraints they have will still not be able to do so. And powerful countries that have been pushing the agendas under all these other forums will still continue to do so even under the UN. So let's deal with some recommendations. I'm about to land, although I'm landing very slowly. What are some of the recommendations? We have work streams, and this one I'll just touch and go. The important thing, especially from developing countries, is to ensure they send people there. This has been quite a problem, ensuring that they send people there that have got the relevant experience, expertise, and historical knowledge, and not just recycling them to just go there, sit in the rooms, and they don't know what they're talking about. This is a major challenge. Political will is very critical. Am I at this? Yeah, we are on the same page. Political will is very critical. As is with any treaty or convention, it will require ratification that has got to go through Parliament for some of our countries that are constitutional countries and so forth. And because of that, some of these matters are left to the technocrats in the revenue authorities, and the politicians are left out of the discussions. So when these things are tabled in Parliament, they just don't know what we are talking about. So we need politicians involved in the process, because they are the ones that are going to have to sign up to these kinds of instruments. We see traction in Africa, for instance. The African Union is gathering together finance ministers, and they're having regular meetings on these matters. I had an opportunity to attend one of those meetings. The African Tax Administration Forum is working together with the African Union to make sure that these matters are attended to. Getting funding is an important one. The UN General Secretary said there will be funding that he will provide for us, but there is also funding that can be got from the UN Interagency Task Force on Financing for Development, which is actually there to make sure there is capacity building for sustainable development for developing countries. Actually, if you look at the UN 24th fourth International Conference on Financing for Development that took place in Sevilla, many of you could have attended, there was a very strong support of creating funding to deal with global governance matters. And then we come to the elephant in the room. The elephant in the room is, how do we galvanize the OECD and all the other bodies to actually work together under the UN. This is going to be quite very difficult, but we are going to need people who are good at diplomacy and understand the technical issues, and they are going to gently talk to the OECD. I don't know how to get us to work together. There seem to be some positive indication that we could do this, because the UN, the OECD, the IMF, they've been working together in issues as Tax Inspectors Without Borders, and also the Platform for Collaboration on Tax. So we have worked together over the years. Maybe if we do not have backlash from the US, for example, there could be possibility of us working together if people see value in this. Delegating capacity building to regional bodies is a big one. Send it to ATAF, the EU, CARICOM. These ones could be able to attend to that. Institutional structures that can help. I think I've set up a conference of parties, a registry of international tax data, UN tax monitoring mechanism that can deal with all those recommendations to ensure inclusivity of countries, a UN tax dispute resolution mechanism. We are having lots of issues with arbitration as a form of resolving problems. Instead of mourning about this matter, why don't we train arbitrators at regional level, at the AU, in Latin America, and the EU, and get those arbitrators to sit in? Because the concern of developing countries is that we are sending all these matters to be resolved in London, and playing field is not normal, the rules are not transparent, and so forth. So it is now time to use this platform to come up with fair and clear rules and make a mandatory arbitration action work, because it has potential to help us resolve tax disputes, including UN sanctions mechanism. Maybe it can work. I could go on and on, but those are some of the recommendations. The paper has been written, and hopefully some of them could be picked on to drive this process forward. So as I end, before you shoot me with questions, I have one for you. The global tax governance has reached a decisive moment. Where do you think we are? Are we at a crossroads, parallel path, a fork in the road, or a roundabout? Do you think the OECD is going to play ball with us? I don't know. That's the aim.
Thank you.